How are you feeling, Mr. Mayor?
Very well, thank you. Not very well, but
I can see now how to recover from such problems. You simply make submissions for 2.5 hours.
and 2 Cokes at lunchtime.
Best cure if it's something you've eaten.
Get the intravenous sugar. Yeah.
As long as you let it go flat.
So, I was reviewing the Touring Tours case study. There's one last case I want to talk to you to, which I think makes the jurisdictional boundaries extremely clear. It's a case called Schaff Telecomunicazioni, something like that. Tab 83. My check ain't too good. Page 2253. And you can see the point I'm going to be reaching for if you look at H4 in the holdings on the law report at 2254. It's reported in the Common Market Law Reports. The ratio is that it was for the National Court and not the parties to a main proceeding to bring a matter to the court. The right to determine the question to the court rested on the National Court alone. To answer a request to amend the questions formulated by the parties in the main proceedings, and here is the language, and it's lifted straight from the judgment, as I will show you, was incompatible with the function given to this court by Article 267 TFEU, and with its duty to ensure the governments of the member states and the parties were given the opportunity to submit observations in accordance with Article 23 of the statute. Now, the backdrop to that holding was this, that some of the parties to the case, T-Mobile, Czech incarnation of T-Mobile, maintains, this is paragraph 27, page 2264, that the questions put by the referring court do not concern the key issue in the dispute in the main proceedings, and propose to the court a number of new questions concerning in particular the determination of items which may be included in net cost, etc., etc., etc. That is functionally identical to Spain's reformulation in paragraphs 37.2 of the questions, 2 questions that it wanted to be put, that it thought was at the centre of the proceedings and hadn't been put. What does the CJU say to this? Paragraph 28, you see, and 29, you see the passages summarised in the headnote. Right to national courts alone, parties may not change their tenor, is what they say at 28. Now, tenor there is used, I think, very much in the continental sense. A tenor of the decision is the decision to refer and the reasons that underpin it. And of course, the reasons that underpin the questions referred by Mr. Justice Butcher are his explanation in paragraphs 38 to 41 of his concerns about the Solo jurisprudence and the Hoffman and Krieg jurisprudence. That's the tenor of the order for reference in continental terms, along with the questions. So the first thing is, it's simply not open to change the tenor, not to the parties to change the tenor of the questions referred. Moreover, to answer the questions, the request to amend the questions formulated by the parties in the main proceedings would be incompatible with the function given to the court by Article 267 and with its duty to ensure parties, governments, etc., can make observations. So you see, just as Advocate Mancini had predicted, the unnecessary linkage between reformulation and unfairness, exactly as happened in this case. In the present case, it's apparent from the actual text of the order of the referring court notified to all the parties that the relevant court is asking the court about the principle of taking into account the return on equity capital, etc. Those are the questions asked. On the other hand, the referring court has not stated there's any need to reply to other questions relating to the determination of items which may be included. Therefore, it is appropriate to respond to the first question submitted by the referring court without there being any need to reply also to the new questions proposed by T-Mobile. Now, that, in my submission, is a proper identification of the jurisdictional or jurisprudential basis on which such a request should be reformulated. It is incompatible with the function conferred by Article 267. In other words, the court's jurisdiction is only to answer the questions put, and what is more, the danger of straying from that jurisdiction in a procedure that very often gives a party one shot and one shot only, written observations, no oral hearing, is that if you allow the parties to introduce new arguments, you thereby generate unfair proceedings. So we suggest that is entirely clear, both as to the reason for staying within the question, a jurisdictional limitation, and the inevitable danger of straying from it. And with respect, these cases, Seski forms a logical part with Turing Tools, Alcatel, and all those other cases. They can't be explained away, as the Commission attempts at paragraph 32 of its intervention or observations in this case. It can't be explained away on the basis that the CJU hasn't identified any function for the National Court. Because what is apparent from these cases is four things. First of all, that it's the National Court's question, fairly construed by reference to its tenor, that sets the scope of any jurisdiction for the CJU at all to provide any ruling on the interpretation of EU law. The second point it reveals is that that boundary is necessarily jurisdictional. Thirdly, the case law reflects that it's only the national law that can find the relevant facts that support a request for reference. And the fourth point is that those boundaries must be observed in order to ensure fairness. Now, the fact that the CJU hasn't said in terms, there is no role for the National Court if we stray from this, doesn't really answer the point as to whether or not this is in fact a jurisdictional fault line. And it particularly doesn't alter it if, and you have my mantra here, the way these problems are solved in practice is by re-referral, because all of that is then part of the frozen conflict. The very first point you have to grapple with, however, is there a jurisdictional fault line? Is there a limited conferral of power on the CJU? To which the answer is yes. The CJU says so. That's what these cases say. The question that then arises is who decides, and in particular who decides after Brexit, whether that fault line has been crossed. And I could take you to Wünsche number 2, or indeed Cabot number 2, both cases of re-referral, both in the context of fairness issues rather than answering questions that haven't been put, that show that the solution is re-referral. And you have my basic point that no longer works. Now, much was made about the architecture for implementation of Brexit, HMRC imperfect. In my submission, nothing turns on any of that. I don't have a word of criticism of the analysis of this court in HMRC imperfect. That was a perfectly, forgive the pun, straightforward case calling for the application of a judgment where none of the types of issues that now confront you arose. It was an unproblematic case, much like the Supreme Court's ruling in the earlier Fratilla litigation, where another reference was sent by the Northern Irish Court the day before Brexit and disposed of an appeal in the Supreme Court. And the Supreme Court simply applied the ruling, which was clear. What none of that does in my submission is answer the problem that arises in this case, where, under the terms of Article 267, as imported into Article 86, a jurisdictional problem arises where the CJU extends impermissibly its jurisdiction by answering questions that patently haven't been put. That's the unresolved issue. And as I said yesterday, you can't solve that by simply taking the benefit of what the CJU says about bindingness without the burden of the dialogue mechanism to solve the problems. That's to ignore the problem in my submission. You have a hard choice at the end of the day as to whether or not you decide that you ultimately are the keeper of that competence line as Mr Justice Butcher concluded correctly in our submission, this court is in line with the approach of the Supreme Court in EMIA, or whether or not the only custodian of that a particular boundary is the CJEU, with the result that, as my learned friends on the other side of the court argue, it matters not how egregious the excess of jurisdiction or how egregious the unfairness, this court is bound. That's the point for decision. And we say nothing that my learned friend Miss Norris said about the temporal hard edge of Brexit really answers that. Because that argument in our submission really cuts both ways. Because what is evident is that it was a bright line that the UK wished to terminate a decision-making role for the CJEU. It would be most unlikely that it was accepted that the price was the CJEU could make whatever jurisdictional error, conclude what other unfairness it did, with there being no remedy, as being the price of terminating reference to the CJEU after the end of the IP completion day transitional arrangements. That wouldn't fit with the intentions of the contracting parties. And it is the intentions of the contracting parties that is the relevant consideration, because we're in a world governed by the withdrawal agreement, and we're in a world governed by not sincere cooperation between member states, but by good faith under Article 5 as an operative principle of international law. And we say that the answer to that question, parked as it always has been in Article 267, transported as it is to Article 86, and weaponised as it is by this case, has to be addressed by first principles. The first principle is that it is the national court's questions that set the terrain for any particular answer and formulate and set in train competence. That being so, the CJEU can't use the occasion of a reference made shortly before IP completion day to shoehorn in whatever answer or whatever point it may wish into an answer to a question that doesn't raise that issue in order to get its last word before Brexit. That's patently not a sensible interpretation to apply to Article 86 through to 89 consistently with the principle of good faith. Secondly, given the termination of the dialogue that is inherent in this process, it makes it all the more critical that there should be a properly constituted reference with only the facts that the National Court thinks is material before the court. So in other words, it becomes not less important, but more important in consequence of Brexit to respect these boundary lines. And the, if you like, the tolerance for that extreme form of question reformulation that begins to look like new questions has to be reduced, because there is no opportunity for re-referral, and a somewhat stricter or more exacting approach may be required. The third point is, it doesn't answer the question to accuse the English courts of a lack of good faith or sincere cooperation, if in fact the root cause of the problems lie with the CJEU. One can't simply answer the question by saying, well, it's your fault for not applying our reference if there's a problem in the reference to be applied. And that's all the more so where it's the reference process that has led to the incomplete facts, the incoherence, and factually wrong statements. The danger is if the CJEU takes a point of its own motion in that context without informing anyone, there is an unremediable fairness.
I don't want to stop you, Mr. Delamere, but I feel it's going round in circles. I mean, these are really just repetitions of the submissions made yesterday and this morning, maybe with greater vehemence, but they're still the same submissions, and we've got them. Okay. You may rest assured.
I stand duly admonished. I will move on.
Not admonished, but I just think.
Well, I don't want to be unhelpful.
I think
That's
we're losing.
certainly not very good advocacy. So
We're losing time if we go round in a circle.
Understood, madam. Let me deal very briefly with the suggestions that all of this is indeed genuine and legitimate reformulation of the question. Let me put my submissions on that very pithily. Having taken you in great detail through that material, it is not an argument that can be given any credibility in my submission. It's absolutely abundant what the contours of the points referred were. Spain itself always understood, indeed formulated itself, these as being distinct, hermetically self-standing points. It did so in its respondent's notice and thereafter. For it now to say, in consequence of its own elision of the points in breach of the judge's direction, that effectively these, the judge's order for reference, these were always the same point, one bleeds into the other, is simply not credible. And it is a matter of regret that the Commission also makes that argument, instead of, as we submit, confronting what it should confront, that the CJU has in fact answered questions that weren't referred, and that, and only that, being the subject of investigation, rather than suggesting that there has been proper reformulation. So, I will move on to the topic of procedural fairness at that juncture. This is the first issue on our respondent's notice. It's a point the judge did not resolve, though he did state in the judgment at paragraph 241, core bundle tab 9, page 274, that if he had needed to decide it, it was an argument that had considerable importance and merit. And the propositions supporting our case really boil down to these four, each of which I'll expand. The CJEU is obliged to conduct its proceedings in a fair manner, which ensures the right of all parties to be heard is respected. That's a right arising from Article 47 of the Charter. It's also a general principle, all of which are binding on all of the institutions of the EU, including the Court of Justice. It applies just as much in the preliminary reference procedure as it does in contentious proceedings, direct actions, etc. before the court. And that's because the preliminary reference procedure is no more than a step in the proceedings before the National Court, which must respect that right. Second point is that that right to a fair procedure is catered for by certain features of the preliminary reference procedure. And it's catered for, here I am repeating myself, by the fact that re-referral is the ultimate solution to the problems, as CABA number 2 illustrates. The third proposition I can take briefly because I don't want to repeat myself. The procedure was not fair. It was conspicuously unfair. The case was decided on an argument never put to us. And the fourth point is that the consequence of all of that is an obvious outcome. The judgment can't be relied upon without further breach of Article 47 or the general principle it codifies, because this court, as much as the CJEU, is obliged to ensure that the process as a whole, the CJEU reference being cassation effectively in the proceedings, is one that gives my clients a fair hearing. And if that can't be supplied by re-referral, it has to be supplied by this court. So the fact that there is no means to use the CJEU to remedy the unfairness, the remedy that loyal cooperation would require to be used, means that the only party that can provide a remedy for the CJEU's unfairness is this court. Now, if we can start with the relevant legal framework for point 1, can I show you the text of Article 6 of the Treaty of European Union, Authorities Bundle, tab 7. Article 6. 6.1 recognises the rights and freedoms codified in the Charter, fundamental rights. The provisions of the Charter shall not extend in any way the competences of the Union as defined in the treaties. The rights, freedoms and principles in the Charter shall be interpreted in accordance with the general provisions in Title 7 of the Charter, governing its interpretation. They're basically codification of the EU principles that the Charter applies in the field of EU law. The second part of Article 6.2 is that the Union shall accede to the European Convention. It has not, in consequence of the famous opinion. For some reason, we failed to spot an error in our skeleton suggesting it had, for which we apologise. And the third point is that fundamental rights, as guaranteed by the Convention, and as they result from the common constitutional tradition common to the Member States, shall constitute general principles of the Union's law. And what that says is, in effect, that irrespective of the Charter, the general principles, the fundamental rights identified by the Court's case law, all govern the activity of the Union. And that case law, it should be remembered, was generated by the Solanga 1 case, because it was in consequence of Solanga 1 and the German Bundesverfassungsgericht's weaponisation of the Grundgesetz that the CJU discovered its fundamental rights jurisprudence in the 1970s. That provision is, if you like, the most obvious evidence of the frozen conflict on the main terrain that arises in terms of substantive conflict, which is as between constitutional rights and obligations and norms and provisions of the different member states and the operation of EU law. And while we're here, could you also notice Article 5, because that makes the point I've made many times. The limits of union competences are governed by the principle of conferral. The use of union competences is governed by the principles of subsidiarity and proportionality. That means that the union can only act where it has been conferred with powers, and that process of conferral has both a substantive dimension. There are fields in which the union is entitled to act. It's entitled to act in relation to free movement and matters like that. And there are fields that are outside its competence, or only partially within its competence. But it also has a procedural dimension. It means the organs can only act with the competencies that the Treaty of European Union provides those organs with. And as regards the institutions, you have the Court of Justice's provision, Article 19, 229. The Court of Justice shall include the Court, the General Court. It shall ensure, in the interpretation and application of the treaties, the law is observed. Member States shall provide remedies sufficient to ensure effective legal protection in the fields covered by Union law. And then there are provisions about the composition of the court. Nothing in that amounts to an explicit international law treaty conferral in express terms of competence in relation to the Article 5 principle that the treaty operate on the principle of limited union competence conferral. So next on the Charter, it's tab 9 of this same bundle, page 234, relevant part, Article 47. There are two elements to Article 47. There's the right of everyone whose rights and freedoms guaranteed by the law of the European Union are violated to have an effective remedy. That's a codification of the EU general principle of effective remedial protection. And then there's the codification of effectively the Article 6 right. Everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal. Everyone shall have the possibility of being advised, defended and represented. And those principles apply to all of the courts of the EU, and they govern the raising of points of the court's own motion. And that was specifically addressed in the Commission in Ireland case, which is tab 65 of the authority bundle, page 1610. And you can see what's going on sufficiently from the head note H4 and H5 at page 1611. So the General Court had annulled the Commission decision on the basis of an absence of or inadequate statement of reasons. And that was a plea of public policy which might and even should be raised by the community judicature of its own motion. So in raising that point of its own motion, it didn't thereby act in excess of its jurisdiction. That's, of course, in the context of a direct action, the purpose of the direct action being to secure judicial review of the community's own organs. So a different procedure, and you could see different principles as to why you might raise points of your own motion in that context. And you can see the CFI annulled the decision at issue on that basis. That was all so far so good. But then you get to H6 under the heading Right to a Hearing, and you see the problem. And the problem is that the rule that the party should be heard, part of the rights of defence, it applied to any procedure which might result in a decision by a community institution perceptibly affecting a person's interests. I think $1 billion probably qualifies for that. B, the principle meant, as a rule, that the parties had a right to a process of inspecting and commenting on the evidence and observations submitted to the court. The basic principle of law was infringed where a judicial decision was founded on facts and documents which the parties, or one of them, had not had an opportunity to examine, and on which they had therefore been unable to comment. The principle should benefit all parties to proceedings before the community judicature, irrespective of their legal status. Community institutions might also therefore avail themselves of that principle when they were parties. In other words, it could be invoked by the Commission even though it was a community organ. It's worth looking at the opinion of Advocate General Bott at the paragraph at AG 83 onwards, which is at page 1627. And the whole of the AG's reasoning on this section, starting, I unreservedly accept the Commission's position, is an acceptance of this position as to fairness. And there is a very, very detailed and useful exegesis of the requirements of fairness through to AG 120, which I do ask you to read, not now.
I find it hard to believe this is in dispute.
Well, strangely, as we understand it from Spain's submissions, there does seem to be some dispute. It does seem to be disputed that the principles of fairness apply to the preliminary reference procedure. If my learned friend concedes it's not, then I'll be quiet.
Is it disputed, Mr. Young? I mean,
My
this
lord,
seems the most basic of your pen.
Yes, my lord, the point is that, although my learned friend hasn't shown you the materials, and I will, and I'm sure Miss Norris will, the whole purpose of the preliminary ruling, preliminary reference procedure is that it is not adversarial, it is not contentious, and it has specific procedural rules as to how it's to operate. So the answer is yes. It's not a procedure, a process which
But it has to be a fair process, surely.
Oh, I'm not saying it doesn't have to be fair, but it's fair in the eyes of the procedure of the preliminary reference.
Well, that's a different question. Whether this was fair or not is quite a different question. But that it is.
Yes, and
the Court of Justice can't just simply decide questions referred to it without asking anybody for their comments.
Indeed, and I'll save it for my reply, if I may, my lord. But
I mean, you don't dispute anything that's in the Commission versus Ireland or the Charter or Article 6 or Article 19,
no,
do you?
none of that is an issue. But the whole procedure, which is established for the preliminary reference procedure, establishes what fairness is in the context of that procedure. I hope that's. I'm going to look. Miss Norris, who knows far more about these things than I do, will, I'm sure, in due course,
Well, we haven't got unlimited time for this part.
No, I appreciate that.
It's already 2:30, and I can't see how the club is going to deal in the next 45 minutes with the question of issue estoppel, which I said was troubling the court about 2 days ago, relating to the award, and everything else. If we're going to be looking at the Commission for Ireland, which is something that we've read 1,000 times. And
my lord, I am not for one moment suggesting.
No, okay, well, I'm not suggesting you are suggesting it, but I'm just trying to persuade Mr de la Mare to...
Perhaps I can just suggest that the procedure established for the preliminary reference process has been deemed to be fair. I'll leave it at that.
Right.
I'm afraid I don't find that an entirely clear answer.
Okay, well, you're passing
So,
like ships in
I
the night.
won't elaborate any further on the
Mr. de la
application.
Mare, you have made your submission very clear. This was not a fair procedure. You've taken us to the factual basis for that submission.
Yeah.
You say what you say. Mr. Young is not willing to give any quarter, as I'm used to on this case.
I will give quarter, my lord. I will say, yes, fairness is required, but what fairness means is colour is sensitive to the process.
Obviously, one might say.
So,
okay.
so that I hope that's an answer.
Yes, thank you. Okay, Mr. de la
So,
Mare. I mean,
if it's conceded, as I understand it now to be, that Article 47 applies to the process, of course, we accept the principal way, as the CJU itself has said, that fairness is discharged, is by operation of the preliminary reference in line with the rules that are designed to ensure fairness. That's the critical issue. And the rules require the parties to stick to the questions referred. The rules require the parties to address the facts in the order for reference.
And you've said all this, and you've said that this didn't happen, and we understand that you say that.
Well, again, I don't want to labour the point, but there have been problems where points have been raised by the Advocate General of their own motion. If my lord's familiar with this case law, I won't take you to that either, but the leading case is a Mesa Sugar, and it's the reason for which there is a procedure in the rules to reopen the procedure after the Advocate General's opinion. But one of the peculiarities of the CJEU rules is that there is no provision to reopen the court's judgment. There are such provisions, as I remember it, in relation to direct actions, but there are no such procedures to reopen the judgments in relation to preliminary reviews.
Which raises the question you spent a lot of time on.
It does. And it means that the Court of Justice doesn't have the facility, for instance, that the Supreme Court exercised in part of the Assange litigation, where the complaint was that the case was decided on a provision of the Vienna Convention that hadn't been put to him, where the Supreme Court reopened the case to reconsider that particular point. There is no such facility, and that's what creates the problem that we have. We know, because of cases like Fiteron and the case of Stesky that I took you to, that any departure from the procedure produces unfairness, and that is what's happened in this case. So I won't repeat, because my Lord's been very clear with me, I'm getting boring. I won't repeat all the reasons why we say it's unfair. Let me move straight to the issue of consequences. Because we say such an unfair process does produce remedial obligations for this court. The first plane on which it produces consequences is when you come to consider the issue of issue estoppel, because the ordinary circumstance is only a two-way, if you like, between the justification of the national procedural rule on the one hand and the EU principles of equivalence and effectiveness on the other. And in this case, it's in fact three sets of considerations that have to be considered, because the CJEU rule in question, the foundation for the argument of an impossibility in practice, is one that has been reached by an unfair process. And the court must take that into account when deciding whether or not to adhere to the national issues law. The second point is kind of mutually reinforcing point. The fact of the procedurally unfair or defective procedure in this case demonstrates in my submission very clearly why the jurisdiction of the CJU must be strictly limited to the four corners of the questions referred. Because if you adopt the approach employed by the learned judge and simply apply part one faithfully, the questions which were referred and on which everyone has been heard, all problems of unfairness fall away. And it's a further very good reason for saying, actually, when we come to that difficult competence question, the only answer can be that we, the National Court, are entitled to say, as the judge said at paragraph 210, following the EMIA line of reasoning, the same must apply in this circumstance. I am not bound. And the third point is obviously the interface with CABA number 2. It's back to the same old point that the cure for all of this was re-referral and it's not available. And we say that's why this court has to give effect to our fundamental right to be heard, in this case, by drawing the line in question. Now, I'm not going to go through all of the club's responses to these arguments. The main response advanced in my learned friend's skeleton arguments, Spain's response, the main arguments seem to be the following. First of all, well, you can't make these arguments because the preliminary reference procedure guarantees fairness. And the answer to that is it only guarantees fairness if it's adhered to. And you have my basic submission in relation to that. The fact that it is not a full-blown piece of litigation but a cassation hearing in our submission has absolutely no impact on the obligation to ensure that the end result is in fact fairness. Why else would there be an obligation to reopen the Advocate General's opinion if a fresh argument has been raised? And it was in the context of preliminary rulings that that power was discerned. So that can't be an answer. Secondly, and this seems to be the main answer, there's an extensive reliance upon Strasbourg case law, and in particular Strasbourg case law in relation to breaches by the EU, CJEU. And in my submission, the argument developed over paragraphs 27 to 42 and 43 of my learned friend's responsive skeleton argument, which we address in our supplementary skeleton at paragraph 18, is a pretty transparent attempt to import the ECHR's distanced review, applicable only because of its position as an international court sitting outside the national legal system, providing remedies of last resort on such an international plane. It's an attempt to import that standard of distanced review into the national court, where there is no such distance review. The principles are simply those of Article 47, the general right to fairness that it codifies, as ordinarily applied by this court. And what they try to do is effectively import the sort of Bosphorus protection of the CJEU, which is a line of reasoning in the European Court of Human Rights that says the EU is generally operated in accordance with the rule of law, and therefore you're going to need to show something pretty special to say that there's been a breach. And none of that applies because we're not in the ECHR. And what's more, even the Bosphorus line of case law ultimately requires, when you work your way through the Bosphorus test, proof of compliance with the ECHR on the facts of the particular case. And that's the plane on which we put our complaint. We're not complaining about the CJU's procedures in general. I'm not saying the preliminary reference procedure is inherently unfair. It's not what public lawyers would call these days a case of systemic unfairness. That's not our case. Our case is something went very badly wrong on the facts of this case. So with respect, all of that is a manifestly bad argument. Then Spain's third response is an argument that attempts to magic up some kind of no difference test. And at its high point, it seems to suggest that the threshold that we have to pass is to show that the arguments that we would have made would have had a decisive influence. There is no such test in any of the case law. If you read the Jehovah's Witness case, which is cited for that proposition, it simply does not say that.
Even a human rights lawyer would know that it is no answer to a claim of procedural unfairness to say I would have won on the merits, and it makes no difference.
Well, sometimes some kind of low threshold test of materiality is operated. Sometimes there's a test operated that you can say it wouldn't have made any difference whatever you have said. There's no trace even of such a test, and this case isn't in that camp. And in fact, the operative threshold is that provided by Commission in Ireland.
Yeah.
And there's no such threshold to say it wouldn't have made any difference, there's no reasons you could have given. And then the test of decisive influence could only be, I mean, how do you even begin to satisfy it? It's an utterly circular test. How would you ever satisfy that test in any event? So those types of arguments, I do commend the authorities we set out in response. They show that there is no such test. And the fact that Spain is driven to that argument is in itself telling. Then fourthly, Spain suggests it's for the club to show that the proceedings were unfair and that the issue of law in Part 2 wasn't argued and that we've discharged that burden. Well, don't accept the way it's put, but however it's put, I suggest we've discharged any such burden. What's more, the contents of the order for reference, the Advocate General's opinion, the measures of instruction, the way the case unfolded, the contents of the EJEC, are absolutely plain. As is the point, and no one has suggested otherwise, that if there had been an argument about the basic approach at paragraphs 53 to 58, there would have been howls of protest, and many of the arguments that you've heard today would have been ventilated in response or attempted. There's just no evidence in the process that the CJU's core reasoning was put to us, which it wasn't. And then, fifthly, Spain has attempted to suggest that we have to show that the argument of the CJU was, here I quote, not unrelated to any arguments raised by the court, paragraphs 35, 2 and 45. And that, on a number of levels, is the meat of Spain's response. And again, if you turn up the cases that are said to support that proposition, they say no such thing. Advocate General Colomer in Cabba number 2 doesn't say that. The Jehovah's Witness case doesn't say that. The Goshawk case doesn't say that. There is no such test. And what's more, I come back to the point I made on opening yesterday. Ultimately, these are judgmental issues about whether or not a point that is forensically distinct raises separate legal arguments, separate considerations, and point has been put to the party. And we say, in that judgmental exercise, no one was better qualified than Mr. Justice Butcher to reach a judgment on that point. And he plainly thought there was very substantial merit in our complaint, that this is never the case we thought we had to meet. So overall, and now I'll conclude and hand over to Mr. Hancock, the bare fact remains the CJU took a point of its own motion without affording the club a right to be heard, and the only answer to its conduct in so doing, in the binary world we are now in, is to refuse to apply that part of the judgment to the facts of this case.
Thank you. Mr. Hancock.
Hello, my ladies. Just before I go on to Article 34.1, which is what I should be addressing the court on, can I raise one point in amplification of the point that Mr. de la Mare has made by reference to the prestige number 3 and number 4, and it's the Assenshaven point. You may remember that I referred the court yesterday to the fact that the Court of Appeal in this country held that Assenshaven was not applicable to arbitration agreements. And Spain sought permission to appeal from the Supreme Court in relation to that issue, and Spain put the judgment of the Court of Justice before the Supreme Court, along with an amended notice of appeal.
Spain sought permission to appeal from which judgment?
From the Prestige number 3 and number 4.
Number 3 and 4 is which one? Is more big?
No, it's the November 23.
Ah, November 21.
And in that case, it was decided, it was argued that Assenshaven applied to arbitration agreements.
Yeah.
And the Court of Appeal decided, no, it didn't. Spain then sought permission to appeal in relation to that issue. Spain amended its notice of appeal after the CJEU had given its judgment and sought to rely upon the CJEU's judgment in support of the proposition that the Assenshaven case did apply to arbitration agreements. The Supreme Court refused permission to appeal from the Court of Appeal's decision on that issue, saying that there was no arguable point of law raised. So as far as the courts of this country are concerned, this goes back to a point my Lady Justice Falk made yesterday, the proposition that a party can avoid the obligation to arbitrate because arbitration is essentially caught by the scheme of the regulation is not a proposition that can be countenanced.
So as far as the law of this country is concerned, it stops at this level at the moment, but the Supreme Court has refused to take it. So
Yes.
it tacitly endorsed it.
Yes.
And so far as this court is concerned, therefore, we are bound to find that Assenshaven does not extend to arbitration, and so you can't say that an agreement to arbitrate flouts a rule that says that as a matter of within the treaty, you have exclusive jurisdiction in a particular court.
Yes.
Yeah, that's what it really amounts to.
Yes, it does, my lady. And that's why I raised the point at the outset. Let me turn then to Article 34.1, which in many ways, in a sense, is the obverse side of the coin from the discussion that we've been having in relation to Article 34.3. Because what the debate here is about something that the Court of Justice did not say, because it didn't answer the question in relation to Article 34.1 as it applied to arbitration awards. And the court, that is to say, did not answer this question. And Mr Young accepts that. Mr Young said, I think, again, in response to a question that my Lady Justice Falk put, if you look in this judgment for a statement that Article 34.1 applies to an arbitration award and a res judicata arising from an arbitration award, you will not find it.
Yeah, well, we had lengthy argument as to why you might be able to imply it and all that
Absolutely,
kind of stuff,
yeah,
and we had reference to paragraphs 45 and 58 and 59 of the Court of Justice, and we've looked at all that.
And I'm going to go through that as well.
Well, you can go through it, but it's pretty obvious that it doesn't add up to a row of beans as saying that's what the Court of Justice said, because it didn't say it, as Mr Young accepted. So I wouldn't waste too much time on that.
No, but that's the start point.
Yes,
I would
that's the
respectfully
start
submit.
point.
So that's the start point.
You do have to deal with the stuff about mutual trust and Articles 47 and so on, which he said implies it or is to be taken as meaning it or something like that.
Well, let me come back to that in due course.
I think that's based on paragraph 58 of the Court of Justice.
Yes. But so it follows that in relation to my first proposition, there is no binding decision of the Court of Justice. And therefore, in my submission, it follows that this court has to do its best to determine what the right answer to this question is.
I mean, there's another point, isn't there, which is that the the regime in some way of the regulation means that any kind of res judicata is out with 34.1. It's the lex specialis point, I suppose.
Yes, it is.
And so that if it's not within 34.3, it can't be within 34.1.
That's what's said. And my answer to that is that 34.3 deals with judgments, not arbitration awards. So,
Because that's what it says.
because that's what it says. And then actually the question becomes an entirely different question, which is, as a matter of public policy, under Article 34.1, does an arbitration award, which is not catered for within Article 34.3 or Article 34.4, does an arbitration award give rise to a binding res judicata as a matter of national public policy and European public policy? Those are, as it were, the two steps in the logic. Because
Well, I mean, it's got to be. I mean, I'm sorry to curtail the argument, but I mean, we're pretty au fait with this argument. I mean,
Yes.
the first question is whether, as a matter of national law or municipal law, there is a public policy that says that we should give effect to arbitration awards under our law.
yes,
And I would have thought that's fairly obvious, whether you call it sanctity of arbitration or arbitration being something the parties have agreed to and therefore commercial people should be allowed to do that. But then the second question is whether there is some rule of European law
Yes.
that says this is a type of public policy that is outside Article 34.1.
right.
That's what Mr Young says.
But if I take those 2 points in order, in relation to the first point, Mr Justice Butcher held quite clearly that as a matter of English public policy, then a res judicata arising from an arbitration award was indeed a matter of English public policy.
Yes.
And we would say, we would submit.
So what Mr Young says is, well, okay, that may be the case, but as a matter of European law,
Yes.
you're entitled not to look, I can't remember the words and I can't remember the name of the case, but you're entitled not to look at the public policy itself, that's a matter for the national court, but you are entitled to look at the
Limits.
the ambit, what?
Limits.
Limits, that's
Limits
right.
on public
What's the
And
case?
I think the cases your lordship is thinking of is the Crombach case.
Cromback,
Yes.
yes. Well,
And the Crombach case, your lordship mentioned the test yourself yesterday.
paragraph 38 is.
Absolutely, where it says that it must be a rule of law which is regarded as fundamental by the country in question. And so you are still actually looking at the law of the country in question, and you're asking whether, pursuant to that law, that rule of public policy is regarded as fundamental.
And this is something, I mean, the reason why I've expressed interest in this point is that this is something that the CJEU, even the stuff that Mr de la Mare has, I'll be polite, gone on about quite a lot, namely the reference and re-reference,
Yes.
cannot help us with, because we cannot re-refer this question to see if it is within the limits or not. We have to decide
Yes.
whether
Well,
it is.
you can't refer any of it.
No, we
as
can't
Mr.
refer any of
Blair
it,
has
but I mean, this-
said on a number of occasions. But you're quite right that, and perhaps I should go
But I
back.
mean,
a stage.
what I'm really saying is, uncontroversially, we have to decide that.
Well,
You know, we are definitely not, anyways, it seems to me, speaking only for myself, bound by something the Court of Justice did not say.
Right.
We have to decide if Mr. Young's submission on European law is correct or not correct, and we can't refer it.
Well, then, Mr. Young has not shown you any European legal authority to the effect that a national legal system which regards a res judicata applying as a result of a binding arbitration award between the parties would be one which does not or cannot qualify as a public policy within the meaning of...
He asks us to infer that
Yes,
from
he asks you
various
to...
paragraphs of the Court of Justice
But, the,
and paragraph 78 of the Act.
but again, the problem with that is one might have thought that if that is what the Court of Justice was intending to say,
Said it.
that they would have said it.
I mean,
And they didn't. They didn't refer to Crombatch.
I
They
hate
didn't
to say
refer
you're pushing
to
it an open door that they might have
public
said it.
policy or any of that. So you're
And
asking...
you could even go so far as to infer that they deliberately left it well alone.
Yes.
Well, I mean, it's possible. I mean, so, we're
Yeah.
having a discussion. It's possible that there are many judges there, and we know how the Court of Justice actually works. They all sit about and they've got a draft by the rapporteur, and one judge said, I don't like paragraph 54K, and they say, okay, we'll cut it out then, and then we'll do it without it.
Yes.
It may have happened, for all we know.
Absolutely. But again, so it's common ground that the Court of Justice haven't actually said, haven't answered this question in terms.
Yeah.
It's common ground that the question in those circumstances would be one of public policy under Article 34.1. It's common ground that that would involve two questions. One, is it a matter of national public policy? Answer, yes. Is it a matter of national public policy which is so important that it amounts to a fundamental rule of national public policy? That's a matter of English public policy.
Yeah.
And
is it within the limits that the EU allows?
and there's nothing in the judgment of the Court of Justice that gives you any guidance on that second topic at all, because they don't address it.
Well,
They don't address
he says,
it. And
he says they did. He says that there is something that gives you guidance, and that is the ethos of the regulation.
but the ethos of the
Everything in paragraph
regulation does not apply to arbitration.
That's the point.
That's proof positive.
The whole point is
That's the
that
complete
the whole
answer,
point is that the regulation, and this is why this judgment.
I am trying to
With-
put his argument to you.
Yeah, no, I understand that, by the way. But this is why this judgment actually is a rather peculiar judgment, because in one breath, the Court of Justice says that the arbitration exclusion is alive and well. That's an earlier part of the judgment. They approve
And the
West
New York
Tankers and
Convention.
they approve the Atlantic Emperor. That they, and I was going to come on to the New York Convention, that they do actually, therefore, make clear that the regulation is not intended to apply to arbitration, and yet it is said that it has an impact upon arbitration awards implicitly as a result of public policy, even though, going back to my Lady Justice Andrews' point, even though arbitration awards are catered for by a completely separate international regime, the New York Convention, to which the regulation is expressly subjected. The recast regulation says where there is a conflict between the New York Convention and the Brussels regulation, the New York Convention
That's the
prevails.
recast regulation,
Yes.
but not the old one.
The judge found
The old one's silent.
the old one is silent, but the logic of the situation is that the position was exactly the same under the old law. And
I
that's what
I didn't understand that to be disputed. No one is
No.
drawing a distinction between the recast regulation.
I don't think it has been disputed, my lady, and certainly that's what the judge found, that the position was the same under the recast regulation as it is under the...
That's Article 78, is it, of the recast?
It's one of the recitals of the recast.
Oh, is it?
Yeah. Yes. Your Lordship is quite right. It's recital 12 and it's Article 78 as well. Yes. And I'm reminded by Mr. Thompson helpfully that at the time of the entering into the regulation, it was dealt with as a matter of the relative hierarchy of conventions, because the New York Convention was a convention which was already in force at the date of the entry into the Brussels regulation. And as your Lordship and your Ladyships will remember, then the reason why arbitration was excluded from the scope of the Brussels regulation was because it was the subject matter of the New York Convention. And I don't know whether your Lordship and your Ladyships recall, but there was at the time a debate within the European Union as to whether there was going to be a new convention dealing with arbitration, simply an intra-EU convention dealing with arbitration. That didn't come to anything in the event, but another reason for not actually having arbitration dealt with within the regulation is because they were still in the throes of potentially negotiating a separate convention, intra-EU convention dealing with that aspect. So from all of those perspectives, then if your Lordship and your Ladyships ask yourselves, firstly, does the CJEU expressly decide this point? Answer, no. Does it implicitly decide this point? Answer, no. Does it grapple with the problems that would arise from the interrelationship between the regulation and the New York Convention? Answer, no. The Advocate General does appear to have been prescient in that regard, but in relation to the portion of his judgment or his opinion where he was dealing with the other two questions. And he actually, because of his answer to the other two questions, then he never got to the third question. He only got to the third question on the hypothesis that he was wrong.
But he still doesn't square the circle, in fact.
No, he still doesn't. And that's probably because what he said was, I think the phrase that has been used as light touch. It's also obiter, because effectively he's effectively saying, if I'm wrong, then. But so, for all of those reasons, then I would submit that the answer in relation to 34.1 is that the judgment isn't binding, and that the right answer would be that 34.1 does actually allow public policy to be given effect to in the form of the res judicata arising out of a binding arbitration award between the parties. That's the answer the judge gave.
From which there is no appeal.
Well,
From the binding arbitration award. Now.
Well, it's quite difficult to know in this regard.
Well, they did try. Spain appealed on a number of grounds. Section 67 and so on.
No, your Lordship is quite right that in relation to relation to the arbitration appeals themselves, if this is what your Lordship is thinking of, that's to say,
yeah, well, there's a binding award.
The award of Sir Peter Gross, the award of
No, I'm thinking of the Schaff Award.
Yes, Mr Schaff's award. Yes, they did try to appeal, and as Mr Delamere has said to you, then that they brought their own proceedings under Section 67.
Yes, and Mr Justice Hamlin dismissed it.
That's right. As has also been explained, by bringing their own Section 67 proceedings, they thereby submitted to the jurisdiction of the English
true, but not
court.
relevant to this argument. Yes.
And therefore, the position is that there is a binding arbitration award rendered against Spain, notwithstanding the fact that they have challenged the jurisdiction, but they've invoked the jurisdiction of the English court to determine.
Can I just
that
ask you
challenge.
this? I mean, you know, you may have noticed that the court has some sympathy with this point at the moment, as presently advised. If it's right, why do we need to decide any of the very interesting questions raised by Mr. Delamere?
Well, the answer, my lord, is twofold. There are two short ways through this appeal. The first is the issue estoppel point arising out of Mr Justice Hamblin's decision. The second is this point. And the third is submission to the jurisdiction all those years ago, which probably feeds into the issue estoppel point. But so...
it is discrete from it, though.
It is a discrete point, but I think the answer to your Lordship's question is if you decide this point in favour of the club on this appeal, nothing else matters.
Yes.
So if that's the reason for your Lordship's question, then I hope at least that's a short, pithy answer to your Lordship's question.
Yeah.
It doesn't make any of the points that my learned friend has made
Doesn't make them any less interesting.
any less interesting and important.
Or more interesting.
Or more interesting.
And important. And of course,
Or less controversial.
Yeah,
Doesn't
or
make
less
them any less
controversial.
controversial either.
on any view, then this decision of the Court of Justice is a controversial decision. Your Lordship and your Ladyships will have seen the academic commentary in relation to the decision. Now, it may be, Mr Young says, well, actually, it won't matter anymore going into the future because we're no longer, won't matter anymore to us in this country because we're no longer a...
No, but it's creating chaos for every other member state.
Yeah, absolutely.
I mean, potentially.
Absolutely.
Because actually arbitration is very important.
Absolutely.
But anyway, I mean, don't let me... I mean, that's not our problem, but it's... What we say about it doesn't solve those problems at all.
No, it doesn't. But
I mean,
your
that's
Lordship
the whole trouble.
Your Lordship is quite right.
The whole trouble with Mr de la Mare's argument is that the decision of the Court of Justice affects 27 current member states, whatever we say.
Well, except for the fact that if this court says that the decision of the Court of Justice was reached on the basis of a misunderstanding as to the facts,
Well, then,
on the basis that it was an answer to a question which had not been referred, well,
yeah, but
then
we wouldn't bind anybody.
it wouldn't bind anybody.
Yeah.
But as far as the other member states were concerned, they might well then say to the Court of Justice of the European Union, we'd like a re-reference, please, in relation to this question.
But the problem I have, as you probably realise, with all of the arguments that have been put forward about the decision of the Court of Justice is, whilst it may have been what one might call politely a bit of a mess and unfortunate in a number of ways, the answer they gave to the question was an answer to the question 1 and 2. It wasn't the answer that was expected, it wasn't in the context of the reference, it wasn't in every other way, but it was an answer to the question, namely, yes, but. And the yes, but is quite a traditional way of answering questions in the Court of Justice. And if you look at it from the point of view of hindsight, you say, well, maybe there didn't need to be a reference in the first place, but having made a reference, you are slightly hoist with what the court says. And the problem is not an answer. I mean, assuming Mr de la Mare is right, of course, those are all answers. But if he's not right, and there was an answer given that was admissible, it's not an answer to say, well, it's a hopeless answer, even if that's what you think.
But he's not saying that.
No, I know he's not saying that, but that's not an answer if my
absolutely
reaction that I'm putting.
I absolutely accept that, my lord. My point was simply that, as I've said, the point that was made was that in this jurisdiction, at least, this is a problem which is going to go away.
Yes.
Because the Brussels regulation doesn't apply anymore in this jurisdiction.
Yes.
So this may be the last case in which this type of problem arises.
Yeah.
But as your lordship rightly says, all the way round the rest of the European Union, the same problem is now going to arise. Now,
I mean, it's particularly acute.
The mayor has.
It's particularly acute because sovereign states are involved, actually. If sovereign states were not involved, there would have been probably injunctions granted and things of this kind. But, so this is the sort of worst case possible.
Well, it isn't. It isn't. Obviously, there would be two reasons for not granting injunctions. One would be the sovereign state point. The other would be intra-EU proceedings. So as a result of the Francomo and the West Tankers decisions, then you can't get, and because of mutual trust, the Court of Justice has said you can't get anti-suit injunction.
I mean, look, we can't
court.
solve all the world's problems, however.
I'm not suggesting that your lordship needs to. I'm trying to confine myself to Article 34.1.
Yes, I mean, I think you've made your submissions on Article 34.1, and I think, you know, we get that. Is there anything else you need to say on that particular subject?
I don't think so, my lord, no.
Yeah. Because I think we do want to give Mr Young, we want to stay within the timetable, and we want to give Mr Young a proper opportunity to respond on all the points.
Absolutely. Well,
but I will direct his attention to Article 34.1.
Yes.
I hope, my lord, that I am sitting down just about within my time
You're perfect.
limit.
Mr Hancock, you know, deserve a medal. Thank you.
May it please your lordship, may I first of all, although I'm appearing on behalf of the Kingdom of Spain, may I just express both sympathy and condolences with the province of Valencia and the people of Valencia,
Yes, of course.
of whom you may have heard now over 100 people have died in an appalling environmental catastrophe.
Indeed.
And I would be grateful if I could invite your lordships to associate.
We can associate and will associate ourselves.
I'm obliged.
With that.
I'm obliged, my lord.
Very
It did seem-
willingly, Mr Young.
It did seem to. I haven't been asked to do that by the Kingdom of Spain, but
No,
I wanted to
it's
do that
it's
basically.
terrible. Absolutely terrible.
I'm very grateful, my lord, for that. My lord, it'll probably come as very little surprise to you to know that my reply is currently in a rather ill-digested form, but it probably, as I listened with awe to Mr. de la Mare's
Tour de force?
I was thinking of something more environmentally persuasive, but yes, it was
Whirlwind, perhaps.
yes. I did have that in mind. So if I can endeavour to extract certain points, and if there are the first point, which is the one which I touched upon, which is the role of fairness. Yes, of course, we adhere to the requirements of fairness, and Miss Norris, in due course, will explain, probably with far greater skill and knowledge than I, just how the CJEU works in relation to preliminary reference procedures. But the preliminary reference procedure is rather different from the direct action procedure that one has also before the CJEU. And it is distinctly non-adversarial. So all of the... I'm sure
this case has always been non-adversarial.
Yes. Well, it's... when one looks at... This is set out in Broberg and Wenger, if I may, just to show the court.
But what's the... I mean, I'm sorry to stop you going to Broberg, but I'm not sure this is going to help you. What's the point? I mean, you cannot say that the procedure does not have to be fair if it is found by the court to be grossly or, you know, clearly unfair. So what is your submission? Because it's non-adversarial...
The submission is that the analogy derived from adversarial procedures is not appropriate.
But is the submission not? Is your submission not that whatever Mr de la Mare has shown us does not actually amount to the kind of procedural unfairness that vitiates the decision, because everybody knew what was going on.
Well, absolutely.
The problem is that the answer that was given may have been unexpected, but it was an answer to the question. Now,
Yeah.
if that was right, and I know Mr. de la Mare says absolutely it is not right, but if it were right, then the fact that everybody was taken a bit by surprise doesn't necessarily add up to procedural unfairness.
Indeed.
I mean, I don't see that the point goes much further than that. I mean, you're not surely telling us that if the procedure was unfair and somebody was not given a chance to make submissions about a point that they ought to have been given a chance to make submissions about. But what happened here, you would say, is, well, everybody made submissions. Spain raised full square all sorts of things the judge didn't want them to have raised and had refused to refer. And if that's inadmissible, then they're right and you're wrong. But assuming it's not inadmissible for this purpose, everybody knew it was in play because Spain had put it in play.
Yes.
And I suppose that the high point of their case is the Court of Justice's own direction for an oral hearing, which is rather unclear as to what's going on. Maybe we have to look at France's submissions as well. But if they don't get home on any of that, then your answer is, well, they gave an off-ball answer, which sometimes the Court of Justice does.
Yes. Well, they gave an answer, and Mr. de la Mare has, broadly speaking, given evidence of the way that the club was thinking about it in the course of these.
So that doesn't matter what they thought.
It doesn't matter one jot. What matters is that we see the letter of the 23rd of August, where they make the points perfectly clearly, but basically of which Mr. de la Mare is now complaining.
And they get the Advocate General to sign up to this.
And they did. They did get the Advocate General to sign up, but they didn't get the court to sign up. The court thought that, for good or ill, the question that they were asked was a general question, not necessarily one, however, permitting or requiring a binary answer. And they gave the answer that they thought was appropriate. And that is binding. I mean, the oddity is, of course, that...
well, it's binding unless it's in conflict with something that's already decided by the English court.
Well, it doesn't mean that it's not binding. It just may mean that one has to... It may be that I'm counting the number of angels dancing on the head of a pin again, but it doesn't stop it from being binding and effective, even if there are circumstances nationally which supplant that. But I think...
Yes, I mean, you would accept, I think, that if we concluded that Mr. Justice Hamblin had decided the same thing that the Court of Justice decided differently later, then it on EU law authority, provided to us by Mr. de la Mare in profusion, that doesn't matter. The fact is that Mr. Justice Hamblin's decision was final, binding, and whatever the Court of Justice says different from it is a change in the law for later.
With one qualification, I would agree...
If that's what he decided. If he decided the same point.
I was going to say, my lord, your lordship has already heard me on how the issues were quite different, and yes. I'm going to avoid repeating that. Yeah. There is this question, however, that it is... This is fundamentally the club's appeal against the order of Master Cook, and it does so on the basis of bringing itself within Article 34, 1 and or 3. It needs to prove that it satisfies those requirements the requirement of an irreconcilable judgment and public policy. It needs to do that. Spain needs to do nothing. Spain is not actively precluded by anything Mr. Justice Hamblin decided, even if he decided what my learned friends say he decided. Spain can do nothing, and the burden is still upon the club to bring themselves within Article 34. So it's not just a question of saying, well, there's an estoppel, so that's that. It stops Spain from doing certain things possibly, or advancing certain arguments possibly, but it doesn't facilitate or enable the club to bring themselves within Article 34. That's my qualification. Now that, once again, it may be an over-refinement, but if one says there's an estoppel, one asks oneself the question, what is Spain precluded from doing? And that's something that Mr. Justice Hamblin, I feel with considerable confidence, didn't have in mind. But what are we precluded from doing? If we just stand by and do nothing, can the club bring themselves within Article 34? No, they can't, because Article 34 has been construed to me such that an irreconcilable judgment cannot be relied upon if it is generated in circumstances where the court issuing the judgment could not have done so in its own right, irrespective of the arbitration agreement. So it's only half of the battle to say there's an estoppel.
Depend on what he's open to argue about why the court couldn't deal with it in its own right.
I couldn't possibly disagree with that, my lady, but the point
that's
is...
where the issue estoppel comes in, isn't it, according to the other side's argument. They say, well, you can't be heard to say that the English court doesn't fall within that qualification because you're stopped from saying so.
No, but that's why I put it. I mean, if I may say, I don't accept the premise of the estoppel, obviously.
I know you don't, but I mean that's the argument, and you say, oh well, they've got to show that it is a qualifying judgment, but unless there's some reason to show that it wouldn't be, that the English court wouldn't have jurisdiction, then they get home.
Well, that then depends upon the discharge of the burden of the proof. And I come back to the point.
This case is not going to be decided.
No, I know it's not. I know it's not. But the point I'm making, I appreciate that. Of course, I appreciate that. The point I'm making is, what is Spain actually precluded by Mr. Justice Hamblin from doing and asserting?
No, your point is estoppel is not a sword.
Shield, not a sword.
Yeah.
Yes. I do say Mr. Justice Hamblin was miles from precluding Spain from doing anything, and more importantly, the Court of Appeal was about as far removed from saying it as possible, saying it seemed sensible to leave it all over until a time when the point might actually arise. So insofar as the issue estoppel is concerned, you need actually to go back to the very origins, and
Well, I mean, we have very clearly in mind your point about why the Hamblin judgment and the Court of Appeal do not amount to an issue estoppel, because they did not decide, you say, the same question as was decided by the Court of Justice as to the meaning of Article 33.
And that renders these fascinating questions about CAFRA and fallimento completely immaterial.
Yes, but it doesn't completely render the point I put to you immaterial, which is the argument that the decision that Mr. Justice Hamblin made, if you're wrong about what exactly it was, is final and binding, and it doesn't matter what the Court of Justice said because even if they changed the law and said something different 10 years later, it cannot matter as a matter of your opinion.
My lord, I for obvious reasons, if there was the issue of estoppel, then yes,
Yeah, if you agree.
It's an awful lot of rather
I think you
important
have
stuff.
to, really. I mean, a lot of these things are actually not that complicated because they all come down to what Mr. Justice Hamlin decided, what Article 34.1 means, and what the Court of Justice decided.
Absolutely. I said when I opened the case, I said it was a matter of the construction of a couple of statutes, and that's mostly to do with equitable compensation and injunction.
Well, we haven't got to equitable
But
compensation. That's much more fun.
the points when you cut back to the core, what your lordship has said is absolutely right. That it's a question of the construction, not of half a sentence of Mr. Justice Hamlin, basically, in paragraph 92.
192.
100, yes. And the issue was different, and I'm repeating myself now.
Yeah, there we are.
And
So what do you say about Mr. Hancock's points in the last half an hour?
well, there are a couple of points that I'd quite like to lay to rest that have been made by Mr. de la Mare, if I may.
That might take you quite a time. But
I hope I can do it relatively easily. The first point is that there is no case that he has been able to show this court that national courts have the competence to make determinations on the vires or correctness even of the conduct of the CJEU. The only cases that he's shown you in relation to competence and jurisdiction are where the Court of Justice has, to use my Lady Justice Andrews' phrase, engaged in a self-denying ordinance. What I have shown you is that there are a couple of occasions when national courts have tried to absorb the a sort of a JR equivalent.
what about the alia?
I'm sorry?
What about alia, or whatever it's called?
Amia, what I call the nectar case. Well, what the House of Lords said in that case was simply that the fact findings which underlay the determination by the CJEU were different.
Yeah. If the European Court decides a case on the basis of one factual hypothesis and it turns out the true facts are something different, then what they've decided on the other factual hypothesis
Very interesting.
doesn't help.
It's binding on those facts, but it's not binding on other. And there's a difference. Mr. de la Mare's arguments elided two concepts. One is whether a judgment is binding, and two is whether it is dispositive in any particular factual case. That was why I wanted him to show you at least the last sentence in the Arsenal case in the Court of Appeal, because the Court of Appeal said you are bound by the fact findings effectively as made by the CJE or the ECJ, because they were inevitable facts. So, bless you. The point is that the judgments are binding. They cannot be set aside by national courts. And Mr. de la Mare, for all of his whirlwind-like brilliance, he never once addressed the issue that the purpose of the CJEU is to secure uniformity of application and interpretation. And his suggestion that each national court has the power to review and annul and not treat as binding is frankly a recipe for disaster, which is entirely contrary to the whole ethos of the Union and the CJEU. I accept that if the facts are different, and I come then to the question as to whether the facts are different. Because they aren't. We do have to remember that in this case, as Mr de la Mare has told you, the Court of Justice had the reference from the judge and the judgment of Mr Justice Hamblin and the judgment of the Court of Appeal before them, plus, of course, the Attorney General's opinion.
Advocate General.
They had all of the materials. All of the materials. It wasn't a case that they were minus something. The suggestion that somehow there had been a submission to the jurisdiction of the English court before Mr Justice Hamblin by the Section 62 was self-evident, to coin the phrase from Arsenal in the Court of Appeal. It was self-evident. It was blindingly obvious that there had been a submission to the jurisdiction. But it doesn't mean that because you have submitted to the jurisdiction, the judgment then delivered becomes an Article 34.3 or an Article 34.1 judgment. Submitting to the jurisdiction doesn't affect the characteristic of the judgment, the character. So submission is really nothing to the point. The refusal of questions, well, the Advocate General pointed out the argument, and the club made it express in the letter of the 23rd of August. They were given an extra time, now 25 minutes. It's still 80% longer than the normal time, and there were other observers who could have made precisely the same point. There is no transcript of the hearing before the Court of Justice. But the club had the opportunity to say, you should not look at this because it's been refused. All that you can look at, my lords, or whatever they're called, my lords, the solo and material scope. You can't look at anything else. And if that had been made, if that suggestion had been made, which it plainly was going to be, following the letter of the 23rd of August, the Court of Justice had the right to say either yes or no. In fact, if it was made, they said no. If it wasn't a point that was made, then the club has eschewed the opportunity, the occasion to make it, and not been in any way treated unfairly. Whichever way it goes, it doesn't help the club. And there is, so that doesn't help either.
What do you say about the submission to the jurisdiction, meaning that the points about about the insurance provisions and lis alibi pendens are not open to them anymore because they've lost those points by submitting to the English jurisdiction? And the answer to that is simply, is it that that's a different question because the Court of Justice has introduced conditions that are entirely hypothetical?
Absolutely, absolutely. They just said an irreconcilable judgment has to be a judgment which a judging court
fulfills these conditions
could give in its own right, irrespective
of the factual position, what happened in the litigation in this case. Absolutely.
Yes, it was an entirely, characteristically with the Court of Justice, it was an abstract answer to an abstract question.
And the reasons why the court couldn't give it in its own right, briefly,
are that if the court tried to, then it it couldn't have done it because of lease alibi pendens, because the Spanish proceedings had been commenced earlier, and it couldn't do it because, sorry, my mind has just gone a complete blank. Assenshaven, actually,
So
as a matter of European law, forget English law for these purposes, as a matter of European law, Assenshaven covers both forms of jurisdiction agreement in a policy between non-parties to the current proceeding.
Well, this is where I'm beginning to have a bit of a problem, because it's been said in this jurisdiction that Assenshaven isn't an answer.
No, I would fully accept that, my lady, except that we have got to look at you have to ask yourself, if the hypothetical question is, could the English court leave aside arbitration? Could the English court have given this judgment on its own? Answer, no. I'm sorry, I led you astray when I spoke about Assenshaven. I'm afraid my brain fuzz. It's can the English court?
It's the direct, rather.
Yes.
It's the direct access,
Exactly.
Yeah.
I'm sorry.
It's
just
not Assenshaven. It's right of direct action.
Yeah, direct
so
action.
2 points. Either this alibi pendens, or even if you can get round this alibi pendens because the Spanish proceedings were first in time, it couldn't have decided it, even if there'd been an exclusive jurisdiction clause instead of an exclusive arbitration clause, because sole jurisdiction, Spain, absolute choice.
under the regulation.
Under regulation.
Yes. Yes. I'm sorry. I brain fog at this stage is possibly not surprising. Yes, your ladyship is right.
Right.
And you just have the court producing the irreconcilable judgment in inverted commas has to be competent within those limits.
Yes, even though the hypothetical defendant is domiciled here, you say that wouldn't matter.
No, the hypothetical defendant is entitled. Well, it might. Yes, I think that's right. I'm sorry, I shouldn't have mentioned Assenshaven. It was just
No, all right.
complete aberration on my part. So that is the nuanced answer that was given, as my lord has put it. It was the answer to the question posed. And one thing that, once again, Mr. de la Mare has not shown is any authority for the proposition that a court, a national court, can, by so sculpting its questions, compel the Court of Justice to give an answer which A, the Court of Justice thinks is wrong, B, the Court of Justice thinks is going to be of no assistance, and 3, does send out the wrong message to the referring court. The referring court has no power to compel any answer. It has just the power to ask questions. The Court of Justice has the power to reformulate questions. It cannot do so by way of a self-denying ordinance. By reference to other questions, it can't say, well, we've had a question on this, but we're going to give an answer on human rights. And you will remember that the only point that was expressly excluded by the learned judge in the judgment that he gave for the reference was the human rights judgment. So you could, the Court of Justice couldn't, and certainly wouldn't, have gone on and said, well, human rights are relevant. So, in my respectful submission.
But the point, I think, is that the questions that Spain asked that the judge refused were not the same as the answer that Spain gave to the question that was asked.
Well, Well, they were, if one looks at the formulation produced by the judge. What the judge did, he had 6 actually rather badly formulated questions, rather looking like the design by a camel, or rather camel designed by a committee, which is probably close to truth. What he'd done is distilled from those questions the 3 questions which he thought mattered. He wasn't, as it were, refusing the substance of any of the questions that were asked. He was just saying, I'm going to formulate these questions.
I think he was refusing the substance, but the point that I was making is not that he wasn't refusing the substance, but that he was refusing the substance of direct questions, which he felt he did not need to ask, which were, is it relevant that there is a disalibi pendens, say, which is not the answer that the Court of Justice gave. The Court of Justice said the answer to your first question, which is this a regulation judgment, is it is a regulation judgment if, but only if,
yes,
blah, 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 not this pendens. And the problem with that is that that's different. I mean, it may be wrong, it may be whatever, but it's different.
Well, it's a perfectly rational way of looking at it when one is looking at
on
as
day
they
one, but I never quite understood.
No,
the
it's
but I'm sure you're right.
they had regard, as they themselves said, to the objectives of the regulation.
Yeah,
One of
I mean,
the
when you just analyse it just for 30 seconds, it's not particularly workable, is it? But you don't have to answer that.
The Court of Justice thought it was workable because they gave that answer.
Yes, indeed.
In my submission, it does work. It is workable. But one thing that is very important, and my learned friend Mr de la Mare seemed to say that the condition that was imposed by the holding of the Court of Justice was there must in fact have been a review of verification of the jurisdiction before the judgment could be given. That is not what the Court of Justice said. They said it doesn't matter whether there is or is not a review. There should be a review just to try and avoid prospective irreconcilabilities.
And there wasn't here.
And, well, it's very odd. There was a verification, but it wasn't a verification as to whether the court fell within the objectives, came within the objectives of the regulation.
You say all that's
It was a
irrelevant.
verification saying I didn't need to look at them because the Section 66 application is an application within the arbitration exception. So I verified the compliance with the objectives of the regulation by saying the objectives of the regulation don't apply, which of course...
which anyway brings you back full circle to the question of what Mr Justice Hamilton actually decided.
Yes, absolutely. But it's not... I think it was one of the advantages or disadvantages of a transcript is that sometimes you get things more clearly. And at page 139 of yesterday's transcript, I don't suppose you have it or you need to look it up, but Lady Justice Andrews put this proposition to Mr de la Mare. There was an exercise of verification because Mr Justice Hamblin asked himself the very question which you would expect a judge to do when going through the Section 66 exercise, as the Court of Appeal, the European Court says you do, which is this going to offend Assenshaven? Is this going to offend vis alibi? And decides, no, it is not, albeit in the context of the exercise of a discretion. And Mr de la Mare leapt on it and said, yes, correct, my lady. Now, he didn't ask himself that question. He asked himself whether he needed to ask himself that question in an arbitration application case. So he conducted a verification, but it wasn't the right verification, not the verification that was contemplated that should be done prospectively in the eyes of the Court of Justice.
Well, he couldn't possibly have conducted that.
He
because
couldn't.
He didn't know that was what he had to do.
No, indeed, absolutely. So,
10 years later.
but what one doesn't have to do in any particular case, as a precondition of coming within the irreconcilable judgment provision, is we can make our judgment an irreconcilable judgment if we perform the act of verification, however that verification is achieved. That's not what the Court of Justice said.
No.
I think so when one looks at what my learned friend Mr. Delamere regarded as a misconception of fact, there was no misconception of fact at all that was of any materiality. What the Court of Justice thought was that the verification that was done by Mr. Justice Hamblin wasn't the sort of verification that they had in mind as being performed prospectively following their judgment in other succeeding cases. But there was no misconception about what had been verified, and the court had the judgment. They had the reference. There is no further fact that was not already before the Court of Justice.
Yeah.
So, so there was no missing fact. I say there was no issue with estoppel. There was no point about submission because it can't alter the nature of the judgment, and there was no waiver of rights, which was of any materiality for bringing the judgment within the context of irreconcilable judgment. So, all absolutely fascinating arguments that have been developed with fantastic skill, but they are absolutely irrelevant to the application of the binding judgment, and they are absolutely irrelevant to the binding quality of the judgment. There is nothing that this court can do as a matter of jurisdiction, or indeed as a matter of fact, to say that there was any relevant aberration by the Court of Justice. My learned friend, I think, placed great reliance upon what I still persist in calling the nectar case, the aim, but and I'm sure my Lady Justice Falk knows an enormous amount about it. But all that it was the House of Lords saying that things are different. And in this case, in our case, they aren't.
Right.
So, and for what it's worth, I'm repeating myself, I know. I am not asking this court to set aside Mr. Justice Hamblin's judgment or Mr. Justice Hamblin's order or the Court of Appeal order. I'm not asking a set aside. They are, in a sense, the very premise of my argument. I'm just saying they don't fall within irreconcilable judgment. And that's what all of the authorities that my learned friend has referred to, the CAPFRA principles, are all about setting aside what has gone before.
I mean, it would all be quite unjust if you go along and argue cat and mouse with Mr. Justice Hamlin and the Court of Appeal and the Supreme Court and say this is not a judgment that should be enforced in England and this is not a judgment that should be recognised and blah, blah. And you lose all that. And then you come along and say, oh, well, under European law, it's not irreconcilable, so we can enforce our Spanish judgment.
Yes, well, I would agree. Were it not for the fact,
it all sounds quite
well, were it not
to
for
me.
the fact that when Mr. Smooha and Miss Dilnot were arguing the case before Mr. Justice Hamblin, they said this shouldn't be an irreconcilable judgment. He said, I'm not going to decide that now. I'm going to leave that for later, as and when it arises. All I, Hamblin J, need to do is say, is there a fair argument?
Well, I get all
So there's no. I would agree with the general principle that your lordship has put, but it's just not this case. Now we come now to.
Yeah, and do you agree with Mr. Hancock that if we were to decide against you on Article 34(1), that's the end of the case?
On public policy, that if
Or the end of the whole case?
yes, absolutely. I've just got to track this one back a little bit. Deciding the case on 34(1) involves concluding that there is a principle of English public policy which may or may not actually embrace res judicata as such, which is also within the limits of the EU understanding of that term, public policy, in Article 34(1).
See Crombatch.
Yeah, Fromberg, and going back to Jennard, and it's got to be such that it's manifest, and B, it's to an unacceptable degree. Now, it's not just any offence to public policy and national public policy, even within the European context. It still has to be to an unacceptable degree. And one has to ask oneself, I put it yesterday, I think, in terms of it would stick in the craw of the court to enforce a judgment coming in which was so obviously offensive to English public policy that you really wouldn't wish to soil your hands with it. And an issue estoppel or a res judicata does not necessarily, even if otherwise within the limits permitted by the EU law, doesn't necessarily fulfil those characteristics.
No, but it's not issue estoppel or res judicata that automatically fulfills those limits, but it is the fact that there is a binding arbitration clause and a binding arbitration decision, and this is being flouted and ignored.
Ah, yes, but it's been flouted and ignored. I need just to develop that a little, because what has happened in this case is that Spain, as it were, the litigant, not the state, Spain became involved in 2010 in criminal proceedings against the master. This is going back to the history that Mr. Hancock started yesterday.
Yes.
Now, there was a civil claim only under Article 117 of the Penal Code. Mm-hmm. That civil claim could not exist until there was a relevant criminal conviction.
Well, that was all dealt with by Lord Justice Moore-Bigg, who said that doesn't matter a pig.
I see that, but you've got to ask yourself whether it's an offence to an unacceptable, an offence against...
Well, the unacceptable nature of it is, of course, the pay-to-be-paid clause, really, rather than the arbitration clause.
Yes.
Because, but you can't say, can you? I mean, Mr. Hancock, I will let you speak in a second, but you can't say, can you, that just because there was a criminal case and that gave rise to a civil case, you can ride roughshod over the terms of the policy.
No, indeed not.
Bound under English law.
Except that until there was a criminal... My learned friend has got to his feet. I'm going to give way.
Although the only reason I got to my feet is because the civil liability will not be established until the criminal liability is established, and indeed causation between the criminal act and loss. That doesn't mean that the civil liability doesn't exist at the moment that the the action is brought because what is being asserted is the civil liability under the relevant section of the Penal Code, which is a civil liability, as the experts made clear back in 2013.
Yeah, I called it criminal injury compensation. That's exactly what it is, Article 117. Now, there was no conceivable claim that Spain could make in arbitration, because until there was a criminal conviction, they had no claim, and they could only bring it in criminal proceedings. So once again, it's in the context of public policy to an unacceptable degree. Now, whilst it is true that the learned judge held and found that by 2013, 2015, it was not possible for the club to rely upon the award or the judgment in Spanish proceedings because they'd just got too far. It by no means follows, absolutely by no means follows, that the club could not have availed itself of rights back in 2010. It had the right, as Lady Justice Andrews said, it had the right back in 2010. It only became embodied in an award or judgment in 2013. But it had the right in 2010. What the club did then was specifically not avail itself of the right which it had to make an application. This is in the context of an unacceptable offence against English public policy.
I think that's about the fourth time you said that.
Yes, and I'm sure that's right. And it's important, and it had the right. What it did was eschew the right to make the application. And my learned friend has got to his feet again.
My lord, my ladies, I have, because this is an argument, as I said on the first day, that was put in front of the arbitrators, Sir Peter Gross and Dame Elizabeth Gloucester. They rejected the argument. As a matter of fact, they rejected the argument. It's simply not open, with great respect to my learned friend, to make these statements in the teeth of findings that have been made against him and by the learned arbitrators, from which there is no right of appeal.
Were this part of my arbitration appeal, my lord, that would be an entirely justified point, but it's not. This arises in the enforcement appeal.
Why does that make a difference, Mr. Young? If you run the argument in binding arbitral proceedings, the argument's been lost. Why can you raise it again in a different context? In litigation between the same parties?
Because it's in relation to an issue about public policy under 34(1). It's just in a completely different context. And can I just show you something?
But it's just a value. It's a jury point, really.
Well, it's all right. It's a jury point, but public policy being relevantly offended is fundamentally not far removed from a jury point.
Well, but you can't have a national public policy of great importance which depends on a jury point. It either is a national public policy of great importance that arbitration.
The point of public policy in the context of, and I'm not going to weary my Lady Justice Andrews by repeating it, it's got to be within the European limits.
We get that, but the point is you can't have a European limit that depends on whether or not somebody made an application for a stay 20 years ago. Either the judgment that is in conflict is something that, as a matter of national public policy, is considered a res judicata or an issue estoppel that is important because it's the sanctity of arbitration and because of possibly the pay to be paid clause, or not. and
Well-
because you're trying to take the benefit of something without the burden.
Well, can
All
I
that
just show
might
you
be-
one?
All that
one
might be public policy.
Yes, may I show you one passage, my lord, in the supplementary bundle 8 at page 2134.
How much time are you thinking of giving to Miss Norris?
However much time she would like, my lord. I'd rather thought that she was going to deal with the, as it were, the non-contentious aspect. I thought I had about 3/4 of an hour, or to an hour.
Well, I can't remember what time you started. I think you've had 3/4 of an hour. And I think that's what you had, but I'm not going to stop you. But
No,
I don't want to go on much beyond 4:15.
nor, my lord, do I.
And I would much prefer to get this part of the case out of the way. So if you could, anyway, we're going to a page.
I'm going to show you just one passage in the judgment. This is the judgment of the Supreme Court in Spain in the 2016 judgment.
Which page is it in?
2134.
In which bundle?
Sorry, supplementary bundle 8.
2134.
2134. It's tab 40.
Yeah.
It's just something that when the court is weighing up the issue of public policy,
Yeah.
and I risk of repeating, I don't accept that res judicata is a matter of English public policy. It's an important principle which has its origins in issues of finis, litium, whatever. But it isn't English public policy. But if you just look at the top of the page, 2134, the judgment of the First Chamber of this court of the 3rd of July 2003, that is the Sea Bank case that my learned friend Mr Hancock referred to, declared that the Spanish courts did not have jurisdiction to hear the direct action of a third-party victim against the ship owners' insurers, where the P&I Club rules contained a clause on submission of the contract to arbitration in London. That is what the Supreme Court found as part of its own jurisprudence. But it went on to hold...
We can ignore that because it wasn't argued.
That's exactly it. They
To
were
put it
saying...
bluntly.
Yes. In this case, we're concerned here with the insurer
And
with
of
its
course,
stance.
you've got to remember you're dealing with a civil jurisdiction which doesn't have the same views about precedent as our jurisdiction, and we have to respect
Well,
that.
the Supreme Court clearly thought that its own previous decision was of importance. If it's a bit, and I'm going to give as much evidence as Mr. de la Mare now. There were two other A Coruña judgments, provincial court judgments, applying the Sea Bank. It wasn't a one-off. But the court found that there was a basis for the club back in 2010, perhaps, to avail itself of its rights, including its right to arbitration, which was in existence then and indeed just reinforced in 2013. And they said, with its stance of voluntary absence from the proceedings, didn't submit that or any other cause for contesting the obligation to compensate. Thus, it must bear the consequences.
Treating it as tantamount to a defence, which we all know it isn't. It's a conditioned precedent. One can see very well if somebody doesn't turn up and defend or take a defence, which might otherwise be open to it, they might be open to criticism. But that's just a misunderstanding of the way that these things work. I'm not sure that we're going to get much help in terms of public policy from that particular judgment.
My lady, when the English court comes to consider the meaning and effect of the public policy exception in Article 34.1 within the limits set by European law and with the qualifying characteristics of manifest and to an unacceptable degree. This is the sort of thing which has to be taken into account. It isn't enough just to say there is an issue estoppel, ergo. Perhaps one can put it this way. That the principles of issue estoppel and res judicata are based upon an end to litigation. As things stood at the time when Mr. Schaff made his award, to which jurisdiction Spain never submitted. They never submitted to his jurisdiction, they submitted to the jurisdiction of the courts. So we're looking at an arbitration award to which one of the parties, being res judicated, did not submit. And put it this way, did not submit with perfectly sound reasons, because there was no binding arbitration contract in existence then, which compelled it to. There was subsequently the arbitration construct, which was developed based upon the conditional benefit.
I'm not sure that's true. I think, in fact, it was held against you by the Court of Appeal that you submitted to the arbitration contract by construction when you initiated Spanish proceedings.
Actually, yes, you're right. You're absolutely right. But there was no, I still maintain, there was no arbitration contract. And at that stage, Spain was entitled under the regulation, entirely under the regulation of the insurance provisions, was entitled to continue before the courts of Spain. It may be that there was an equitable obligation which should be superimposed upon that, but Spain did something which was lawful under European law and lawful under Spanish law. So when you're looking at public policy in an unacceptable degree, you have to say Spain was actually doing something it was lawfully under the regulation entitled to do, even though even though there may be an arbitration clause involved somewhere. And it doesn't follow that the enforcement of arbitration clauses is a matter of English public policy. And I can say that because when you look at section 12 of the 12 of the Arbitration Act, you can see that it isn't a matter of English public policy. It's something which is up to the party wishing to have arbitration, developed by making an application for a stay. And it's entirely, precisely the same procedure as is contemplated by the New York Convention, as indeed was contemplated by the case in the Sea Bank in Spain. So it's not a matter of English public policy to enforce arbitration clauses. That's up to the parties. Now, 99 cases out of 100, there will be parties to an arbitration contract, and the answer will be jolly obvious. But when it's a much more sophisticated construct, I won't call it procedural fraud, it's a sophisticated construct, it creates a different question, and you have to ask yourself, what is the public policy of English law with regard to the enforcement of arbitration clauses? Leave aside, the issue is the res judicata merely takes it one stage further.
Well, okay, but the policy concerns the issue estoppel concerned with a previous judgment award of an arbitrator by which you're bound.
That is right. But it doesn't follow.
No, I think we're going round in circles.
Oh, we are going round in circles.
Yeah.
I would infinitely have rather, when my learned friend sat down, had the overnight just to reflect upon a rather more ordered structure to my reply.
Right. Well, I mean, we've got, you know, we're not going to stop you, either of you, saying, I completely forgot to say this in a 7-day case.
I'm anxious to not to waste the court's time any more than.
Okay. Well, subject to coming back and saying you completely forgot to tell us something.
Well, is it one of the other elements of English public policy which got to be brought into account is that at the time, English public policy was materially infected by or influenced by the regulation with its own exquisite insurance provisions, making insurers have to go to the, if they wish to commence proceedings, to go to the court of the relevant injured party. Now, once again, this infects the analysis of public policy. And at the end of the day, the policy of the regulation, the objective of the regulation, and the Court of Justice have told us this, the objective of the regulation is to ensure that injured parties are compensated by the insurers of the wrongdoers who have caused those parties damage. Now, the corresponding public policy, so far as English law is concerned, is the protection of insurers of liability who have the wit to have arbitration clauses and pay-to-be-paid clauses in their policies. It's to protect English insurers from paying on what is otherwise a lawful claim. Now, you have to weigh those, you have to weigh the public policy considerations when you're looking at Article 34.1. I know it's a jury point, but it's a jury point of relevance when one thinks of the objectives of the regulation as then being part of English public policy. So there isn't a bright line English public policy, is the point I'm perhaps making, not very elegantly. There isn't a bright line that says res judicata is public policy and that's the end of the matter. No, it jolly well isn't. English public policy is a much more nuanced concept. That's assuming even that res judicata is public policy rather than a rule deriving from issues, questions of public policy, which is a different question. So we've got to 4:15, my lord. I feel that I'm not going to give Miss Norris any opportunity, and I believe that she wants just to speak to Brussels anyway. I wonder if that might be a convenient moment. If I can just be given a little time to reflect overnight, it might be that I could be much more coherent than I have been in the last.
And I'm pretty reluctant to go on tomorrow. Miss Norris, how much time do you want? Do you want to talk to Brussels?
Well, my lord, one might say that as someone who habitually pleads before the European Court of Justice, I'm very familiar with condensing my oral submissions into 15 minutes.
15 minutes. Yes. Well, if you have your 15 minutes in the morning and giving you the opportunity to condense them maybe into even 10, Mr. Young, I would be extremely unhappy if you took more than 5 minutes.
I'd be unhappy. I'd be unhappy if I took more than 5. But I'm very conscious that those behind me have sent all manner of
notes.
Post-it notes.
Yes.
And replies are always slightly discombobulated things.
Tell them it would be so much easier if they used electronic methods of communication. And they would be sure the note was not
It would
lost.
have even less impact upon me, my lord. But I really will be very quick. But I just need to condense. Okay. I'm sure your lordship remembers from your days when you were here.
5 minutes, and then we'll give Miss Norris up to 15, and then we will commence with Miss Stillnot, I think, on equitable compensation.
My lord, yes.
Thank you, my lord.
Good. Okay. Well, there we are. Thank you all. I hope everybody who's suffering will be better in the morning.
Report rise to favour.